The Supreme Court has awarded former inmate Raymond Morgan $79 million in damages for unconstitutional imprisonment after he served 2,504 days, or approximately 6.8 years longer than he should have. His attorney, Terrence Williams, says this case and others should show lawmakers it's time to change the law. Giovanni Dennis has that follow-up.
In February 2011, Raymond Morgan was convicted in the then resident magistrate's court to 12 years in prison. King's Counsel Terrence Williams, who represented Mr. Morgan in the later stages, explained that Mr. Morgan had, from the beginning, tried to appeal.
He had filed his appeal, but through no fault of his, the appeal was not delivered to the correct office. And although he was in prison awaiting his appeal, for many years, it was not heard. And when it came up to be heard, the court said his appeal had been deemed abandoned many years ago.
Mr. Morgan then applied to the Privy Council, which granted him permission to appeal against the sentence which had been imposed on him, as it was much longer than a resident magistrate could impose by law. The case was sent back to the Jamaican Court of Appeal, which ruled that Mr. Morgan's constitutional right to liberty had been breached.
To the Jamaica Court of Appeal, and the Jamaica Court of Appeal determined that he should have, his period that he served was excessive, and at the most he should have gotten a sentence which cumulatively would have meant that he spent 2,500 and odd days in prison, more than he ought to have.
Supreme Court Judge Justice Wint Blair has now awarded Mr. Morgan $60 million to compensate for the prolonged extension of detention. She also awarded another $10 million in vindicatory damages to account for the seriousness of the breach of his constitutional rights to liberty, due process, and appellate review. The judge then awarded another $9 million in special damages to pay for his legal costs.
It's a significant judgment, because Mr. Morgan is not the only person who has had to wait an inordinate period of time, an unreasonable period of time, before they can have their appeal argued. Others have had to wait long periods, and there are other cases, I'm sure, before the court on this point.
Mr. Williams explained that a major reason for the delays in hearing appeals is because of delays in producing transcripts of the trials.
The court can't do anything, the lawyers can't do anything until you get the record.
The law also states that once an inmate appeals, the system stops counting the time they are serving.
So suppose you have 10 years, a 10-year sentence. You appeal, you can sit there waiting 10 years, and the appeal doesn't come up, and none of the 10 years start to serve, because it stopped counting your time unless or until the judge says so. And the judge will not get a chance to say so until the record is ready. So persons are in great danger of serving practically the period of their sentence, and none of that counting towards their release from prison.
Mr. Williams is calling for this aspect of the law to be changed. He also says it's time for the court to be properly resourced so transcripts can be produced quickly. Giovanni Dennis, CVM News.